Call the second case on this morning's docket. Case number 116803, State of Kansas v. Brandon Fowler.
May it please the court, Caroline Zuschek of the Kansas Appellate Defender Office here on behalf of Mr. Brandon Fowler. If I may, I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
The sole issue in this case is a discrete sentencing issue, and that's whether KSA 216810D9 prohibits using prior convictions to both elevate the criminal history score of a primary crime and to increase the penalty for a secondary crime in the same sentencing. And the answer, based on the statute's plain language, is that it cannot. 216810D9 reads, prior convictions of any crime shall not be counted in determining the criminal history category if they elevate the classification from misdemeanor to felony of the present crime of conviction.
Counsel, this whole case boils down to what does present mean?
Correct.
And I guess my first question for you then is it ambiguous?
No.
Or is it? Okay, I thought you said the clear, plain language. How is it plain that present means the same thing as primary or base?
And our position is that that inserts an ambiguity that doesn't exist. Present means present, and since he was convicted of 2 crimes in the present action, it can't be used in 2 ways in that sentencing, because those are both present crimes. And it's our position that the Court of Appeals and the state inject primary into that definition unnecessarily when the statute doesn't include it.
Okay.
Basically, we think the statute means what it says. It says present crime. Here there are 2 present crimes. And
So you're adding an S to the word crime. I mean, it seems like both sides want something more in the statute than actually exists.
well, it says the present crime, and here there are more than one present crimes. And we know that the legislature has dealt with multiple convictions and other subsections, and has
Right.
also dealt with base or primary crimes by name and other subsections. So I have to assume the lack of inclusion in this statute was purposeful of that, and that present crime means any present crime. And would it have been clearer if they had said any present crime or the present crimes? Yes.
That's the deal. I mean, I
But-
just think both of you need to say it's ambiguous to get to your place as a starting point. That's why I asked my original question.
And I don't think that the language as it's written isn't ambiguous. In order to find in Mr. Fowler's favor with the interpretation we're asking, I'm not asking you to include any additional words. I'm asking you to define present as it is defined. However, I can acknowledge that there would be clearer ways to write this, but not that as it's written is unclear.
So you think present's clear,
Correct.
but crime is singular. So you think we should read that to mean plural.
Well, I think
Let's
each...
do this. Rather than haggle over that,
Correct.
I think you've acknowledged that you basically read crime to mean both of the crimes here. So we'll just assume that as
Okay.
our baseline. If the statute's ambiguous, what is the law supporting you for your reading?
Well,
Or other types of arguments that we entertain once we find a statute to be ambiguous.
Well, again, we would have the canons of construction to fall back on, and those would say that any ambiguity in a criminal statute would be resolved in the defendant's favor.
I think that the rule of lenity may be a little bit more narrow than that, but I understand that the rule of lenity would be one thing you would go to. What else?
And I think that's particularly in a sentencing statute. Also, that, as I mentioned, other statutes do specify primary crime, and they do specify multiple conviction and this one doesn't, so we can assume that they intended present to apply to any crimes in a multiple convictions case, because had they meant it only to apply to the primary crime, they could have said so. Moreover, the principles of the sentencing statutes were uniform sentencing, and this would create the most uniform reading. The most problematic piece of the law for my client would probably be the Vontress case, which is what the Court of Appeals predominantly relied on. And in Vontress, this court held that in that case, because there wasn't a separate penalty attached to the secondary crime, that present crime in that case meant present primary crime. However, this case is both distinguishable, and we would argue additionally that if this court doesn't find it distinguishable, that it finds Vontress was wrongly decided.
If the two crimes, I think there were two, right, charged together,
Yes.
if they were charged and tried separately, would you have the same argument?
No.
And
'Cause-
does that make sense, that the simple accident or fact of whether they were tried together or separately changes the meaning of the statute as it applies to this case?
Well, yes, because the statute says present crime, and if they were tried or charged separately, then one would not be the present crime. So it could be used in that situation.
And isn't that it? But that's exactly what happened here. It was just that they were tried together. In other words, the prior conviction was not used. Well, let me ask it a different way. My understanding then is that there was a different criminal history score applicable to each of these two convictions.
Well, there was no criminal history score applicable to the
domestic battery. Because it's
Right, 'cause it's a
separate and
non-grit
apart
offense.
from KSGA
Yeah.
in the first place.
Yeah.
Or at least it has its own sentencing
correct. It has a
provision.
unique sentencing provision.
So it doesn't even get a criminal history.
Doesn't get a
applied
score,
to
but okay.
it's just a peculiar extra. Yeah. So this is different. Okay.
And I take your point that it seems like that's an unusual result, but the statute means what the statute says, and the statute
Well,
says
let me just ask one more way. This statute it's an anti-double counting statute.
Correct.
Would you agree? That's
Yes.
the whole purpose of this, is to prevent a double count.
that is how I
Is there really a double count in your case?
yes.
How? Because it was only counted once for each conviction. In a different way, it was used in a different way to enhance each of the different crimes, but how is that a double counting?
Because it was used twice in the same sentence.
It was used twice in the same case,
Correct.
but in different ways. And my question is, how is that a double count?
Well, because it was used twice, so that's
Once
two
for
times.
each conviction.
Yes.
And isn't the statute intended to prevent it being used twice for the same conviction?
That is how this court read the statute in Vontress.
Okay.
But again, Vontress just simply said this present means present primary and didn't offer any explanation as why. And we think that present is clear enough on its own that to the extent that you find that not distinguishable from this case, because in the sense the penalty was separate for each, that Vontress would be wrongly decided as well. I guess in summary, we think the plain language should control. We think that plain language is present. To the extent that this court finds that that isn't plain language, we would argue that if they had meant to include multiple, or if they had meant it to mean present primary, primary would have been there, and that they've specified that elsewhere, and that the rule of lenity would suggest that a sentencing statute should be narrowly construed in favor of the defendant if there is any ambiguity.
And I know you're not bringing it up, it's kind of an ancillary concern that I've expressed before, but let me understand the circumstances of the plea. It appears to me that the state, in good faith, and the defendant's counsel in good faith, entered this plea agreement with an understanding of a certain criminal history score and a certain criminal history, which would have left it as I think a severity, it would have ended up being as an E instead of a B.
Correct.
Something like that. And the state in good faith argued that that's what I understand that.
They did.
It's just we get these cases every so often where there's a misunderstanding. But wasn't the plea contingent upon that understanding? Or maybe not contingent, but certainly entered into the nature of accepting the plea, that it would have been a criminal history of E. Is that
Correct.
right?
Yes. Absolutely. And I think that these types of issues come up more often. You know, he appealed from sentencing because that was the most direct way to obtain relief, the fastest way.
Right.
And perhaps he could have moved to withdraw his plea based on the mistaken criminal history score, but the state abided by it in good faith, so he didn't at the time.
No, I understand. Okay, thank you.
Thank you.
Do we have any further questions? Thank you, counsel.
Thank you for your time.
May it please the court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state. The question before the court this morning is whether the defendant was subject to an illegal sentence based on the way the district court handled his prior convictions for domestic battery. And the appropriate starting point then is the language of that statute. And it remains the state's position that 6810D9 validates the sentence that was imposed based on the plain language, in that present crime of conviction does state the primary crime. And that interpretation is consistent with the limitation articulated in the guidelines that the criminal history in multiple conviction cases can only be applied to the primary crime. So if we're talking about criminal history and the appropriate calculation thereof, then we are necessarily speaking to the primary crime which is the only crime that can be impacted by that criminal history. Additionally, the language utilized restricts the term to present crime. It does not pluralize it to say present crime or crimes. Therefore, the aforementioned prescription can only apply to that primary crime. We see from the language of that provision that when the legislature wants to use a plural form, it will do so. At the outset of that, it says prior convictions of any crime shall not be counted in determining the criminal history category. Had it later intended present crime or crimes to be utilized, it knows how to do that. The prior convictions exempted are those which would have an impact on the primary crime or otherwise subject it to modifications of some sort, and that is not this case. The prior domestic battery convictions do not serve to impact the severity level of the possession of methamphetamine offense that he was facing as his primary crime. It does not affect the classification of that offense, nor is it an element of that offense. So this does not run afoul of that calculation restriction. Von Tress and Davis do provide this court with guidance as to how to resolve this issue, and the state would respectfully request that those cases be followed in using it in conjunction with the statute, and would respectfully request that the Court of Appeals opinion upholding this sentence be affirmed.
It's tautological, I suppose, to say when we've got two counsel on opposite sides of an issue and they're both claiming the plain language supports them, that maybe the language isn't so plain. So let's just go back to the same exercise I did with opposing counsel. Let's assume it's ambiguous.
Okay?
Then tell me what canon support you or other legislative history, substantive background considerations at the time of the adoption of the statute, all those things that we consult when something's ambiguous.
Well, obviously it's not surprising that the legislature hasn't been completely clear on something that, especially with respect to sentencing, that they would like us to do. But I think if we look at the guidelines as a whole and how primary convictions are supposed to be handled, and how those are prior convictions are supposed to be handled and how those are supposed to impact an individual sentence has always been assigned to the primary crime. So I think when we look at the intention of the guidelines and that all prior convictions are supposed to be calculated in a defendant's sentence, I think that leans towards the state's interpretation of this provision.
And how about, oh, that's okay. That's fine, thank you.
Do we have any more questions?
Well, that sounded, your answer right there sounded to me, but correct me if I'm wrong, like you were arguing that the legislature only intended prior convictions to be used once.
No, I'm just saying when an individual is sentenced, that all of their prior convictions are to be utilized towards their primary crime. But in this case, there was not a double counting, which is prohibited.
It was used twice, though.
It was used twice, but not in the way that this statute prohibits. What this statute seeks to restrict is that it would twice impact that
The
primary
same
crime.
conviction.
Twice impact the possession of methamphetamine, and it didn't.
When you
Or
talk- I'm sorry.
twice, yes, okay. So, assuming that the statute's ambiguous, what's your best argument that the legislature intended that a prior conviction could be used in two separate ways in the same case?
Well, because here it speaks of so here it speaks to how that prior convictions are to be included in their entirety with respect to a primary conviction. It does not exempt the use in these self-contained provisions like we have with respect to the domestic battery, theft, forgery, all those things. It has not created some sort of exception where those may only be used in the self-contained provision but may not be used with respect to a primary conviction.
If D9 read present crimes of conviction, would you lose? Would the state lose this case?
No, because prior convictions can only be attributed to the primary crime of conviction under the intention of the guidelines. They cannot be.
That's what I understood you to be arguing. So one of your arguments is that even if this statute did say present crimes, we still win.
Correct,
Okay.
because under the intention of the guidelines, they cannot be fielded out to all underlying crimes.
Do we have any further questions? Thank you, counsel.
Thank you.
May it please the court. Just briefly, opposing counsel suggested that the use of the word criminal history indicates that this would only ever apply to the primary crime. That would suggest that this rule would never apply in a multiple conviction case. And if that were the case, I'm not sure why the legislature didn't say so. Like in a single conviction case, this rule applies, and in multiple conviction cases, it wouldn't apply. And it doesn't make that distinction.
Well, it would apply if the crime for which there was a severity level enhancement was also the primary crime, right?
In a multiple convictions case?
No, even a single conviction case.
Well, maybe I misunderstood your argument. I understood you to say that this rule could never apply in a multiple conviction case because you've got your primary crime, which you have a criminal history enhancement, and then
Right.
you have a secondary crime, which is enhanced through an element or through an elevation.
Right.
But what if the primary crime was the crime which was being enhanced? Then this rule would apply, right? Even if there were secondary charged crimes.
Yes.
Yeah, that would still be
Sorry.
a double counting.
Yeah, that would still be a double counting. And opposing counsel also argued that the statute specifically was designed to prevent double counting on the twice counting it for the same crime, but I'm not sure where it says that in the statute. It says primary crime. It doesn't say the same primary crime. So I would think that was another word that would needed to have been added for clarity. And Does this court have any
Any more questions?
Well, we would just ask that this court reverse the Court of Appeals and the District Court and find that Mr. Fallow was sentenced based on an improper criminal history score.
Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.